Welcome to Mortgage on My Mind, where we take the mystery out of mortgages and make dreams of home ownership a reality. I'm Natalie Salins, a top 1% mortgage broker with 20 years of experience, based right here in sunny Los Angeles. If you've ever wondered about pre-approvals, appraisals, or what loan product is right for you, don't worry, I've got Mortgage on My Mind, so you don't have to. Each week, I'll bring you expert advice, real-life stories, and insider tips to help you navigate California's competitive real estate market with confidence. Whether you're buying your first home, refinancing, or just curious about how it all works, this podcast is for you. So let's talk mortgages, demystify the process, and make your real estate goals a reality. Ready to get started? Let's dive in. Hey everybody, welcome to Mortgage on My Mind. I'm Natalie Salins, your host, and today we have Matias Baker Masucci.
That's right. Yes.
Masucci. Excellent. Matias is a seasoned Beverly Hills Realtor with Berkshire Hathaway, and he specializes in luxury real estate across Los Angeles. He has a deep expertise in high-end homes, trust and probate sales, and with international clients, which is an interesting thing for financing, of course, when you have a foreign national. He offers refined, discreet approaches backed by 2 decades of market experience, and he is fluent in Italian, known for his integrity and results, and he also hosts the Probate Realtor Show. So he shares insights on navigating complex legacy transactions, which is what we're going to talk about today. So whether it's a luxury estate or strategic investment, Matias delivers white glove service all around with record-setting results. So welcome, Matias. Thank you for being on.
Thank you, Natalie. It's a pleasure to be here. Thank you for the kind words. Almost as if I've written some of those words.
I love it. Great. So tell me a little bit about what does probate mean?
So probate, yeah. So the term probate, I guess, it comes from the Latin word probare, which means to prove, and it's the court-supervised process of proving the validity of a will when a person dies, or in the case of an intestate death, meaning that there's no will, applying the statutory hair process, which the law determines who gets the estate rather than the wishes of the deceased.
Got it. Interesting. Okay. And what makes a probate sale different?
There's so many factors that make a probate sale different. First of all, the first thing that is obvious, it's that the owner of the property is dead. So I like to say that I speak for those who can no longer speak for themselves. That's like my tagline, right? People who have passed away, and you want to make sure that their wishes are respected and that the process is smooth, because a family that's going through a loss has enough on their plate. They shouldn't be worrying about the real estate transaction. A lot of the times, because of the way taxation works, it's advantageous for a person that inherits a home to sell it because there are no capital gains. So when you pass away, there's something known as a step up in basis. Let's say your parents bought a home for $100,000, and right now it's worth $1 million. You have $900,000 in capital gains. So if they were to sell it when they were alive, they have an exemption, obviously, as a married couple or whatever, but they would have still a considerable chunk of capital gains to pay. Now, in the event that once a person passes away, the beneficiaries of the estate get this step up in basis, which means that there are no capital gains if you sell before the property increases in value. So at the time of death, you have an appraisal, which let's say is going to be $1 million in our case. And then if you sell it for $1 million, you have 0 capital gain taxes. So it's a huge bonus. Yeah. And so it's very advantageous to sell when inheriting a property. And that's why it's a niche where it makes sense to sell a property. It's very rare that people want to keep it. And another thing is this particular area is often fraught with fraud and behavior that is not appropriate, because people take advantage, because the probate is a public process. So that's the issue. So that's why my crusade, if you will. It's to get people to do their estate plan so that you don't go through probate. That's become one of the things that I've focused on the show, is basically have a lot of probate attorneys come on, and estate planning attorneys, and say, look, do your estate plan. It's totally worth it. It's gonna cost you a little bit now, but you're gonna say your heirs are gonna save so much money. So in the case of probate, it's a public process. So what that means is that if you know where to look in the court records, you know when a probate is filed. In fact, now it has become a business to the point where probate leads are sold to different companies of different buyers. Anybody can buy probate leads. So if you are an inheritance, a company
Interesting.
that gives inheritance advances, for instance, if you are a company that does all sorts of things. So because it's a public process, and because people can quickly, you're in the business, you know how it is, you just need a person's name, you can see what real estate they own. So you know
Sure.
the person that passed away, you look it up, you see the properties, and people, unfortunately, over the years that I've been in this niche, I've seen that, some homes gets undersold, or somebody goes direct to the seller. Sometimes these people are like, maybe it's an elderly couple, so the husband passes away, they file a probate. Then they go to the elderly lady. They say, "I'll give you $1 million for your house," and she's, "Wow, we paid 50,000 for it. This must be a wonderful offer." And then you value the property, you're like, it's actually worth 2 million. That's something that, especially in a high appreciation area like Los Angeles,
Yeah.
it's an area where there is a lot of fraud. So I went on a crusade to try and educate people in that regard, to try to avoid probate.
Interesting. And then, so let's say the beneficiary of the home, the
Mhm.
inheritors,
Yes.
let's say they don't sell it right away and they decide to wait a year. So let's say at time of death, the property was worth 1 million, and
Mhm.
then they decide to wait a year and now the property is worth 1.1.
So they would
Do
have
they only have to pay taxes on the 100,000 or on the entire amount?
only on the difference between
Wow.
the time of death and the time that they sell it. So the step up in basis works.
No
It's
matter when you
unrelated
sell.
whether you sell or not. That's when it becomes. Now, in this scenario, appreciation is pretty fast in LA. 10% a year, it's wonderful. And sometimes in certain neighborhoods with certain interest rates, maybe you
Sure.
get that. But the gap in between, usually you may have holding costs. So you can deduct from that gap. If you inherit the home and you have to fix the plumbing, et cetera, those will raise your basis in the home. So even if you have 100,000 gains, sometimes because of the expenses that you had to incur, which are general real expenses, because as we all know,
Sure.
real estate requires maintenance, you may also be able to avoid paying the capital gains even on 100,000.
Interesting. Awesome. So, and so what are the misconceptions of probate? I know from my end, most people think that it takes longer.
Right. If it's handled properly, so generally speaking, there are two types of probate. There are full authority and limited authority. Full authority means that the person, the administrator of the estate or the executor, whether there's a will or not. But in those scenarios, there's no need for court approval. So it goes through the court process, but the administrator, having full authority, can make the decision on their own without asking for permission to the court. Now, there's a lot of probates that are limited authority. I'll give you an example.
Okay.
Somebody who has adult children most likely will have full authority because the beneficiary will also be the administrator of the estate. So in that case, you can see how the interest is, you are protecting your own interest, you're selling the house that your parents lived in or whatever. In some cases, people don't have anybody, or they have a successor, or they have a professional fiduciary that handles the estate. In those cases, you ask for confirmation of sale to the court. In those cases, probates are longer because you have to wait for the confirmation, which in Los Angeles County, believe it or not, the probate court is somewhat efficient. So if you file a
Okay.
petition for confirmation, so the process would work this way. We market the property, we accept that offer, and then we petition the court. Say we have a house here in Beverly Hills and the offer is $10 million and we wanted to confirm at $10 million. The court will set a date for confirmation. So what happens during that confirmation? Because of the way the statute is written, there is a possibility of overbidding. So what that means is that anybody can go to court and they can say, I'm willing to pay more. And if they are paying more, then there is a bidding. The original buyer can defend their bid as well as the person that overbids. Now, nobody can go to court and say, I'm going to pay $1 more. Obviously, that's going to be silly. There is a minimum. The way to calculate it easier is just to say 5% plus $500. In reality, the way the code is written, it's very messy. It is 10% of the first 10,000, and then 5% of the rest of the amount. So obviously in
Okay.
LA County, there are not very many homes that you can buy for $10,000. We just say it's 5%
5%.
plus $500. So for $1
Right.
million, basically the overbid amount is $1,050,500. That's the easy way to figure it out.
Somebody would have to come in and bid that much over.
Yes. And another question that I get asked all the time is, what after that? Like, how much do we go up after that? Is it always 5%? Not necessarily. Actually, the increments are decided by the judge on the spot. So I've been in court sometimes where the overbid goes on for 30 minutes. In those cases, the judge probably underestimated the overbid amount, and they said, okay, we're going to up in 5,000 increments. If you're selling a $10 million asset, if you go up in 5,000 increments, you're not making much
That's going to
progress.
take 2 hours.
A lot of the judges actually are very good at this, and you have 10 overbidders, you have one, you adjust to it. And then once you have confirmation, all you need is the court order signed by the judge that authorizes the transfer of title. You send that to the title company, and they will insure the title. It's very similar, like in a normal transaction, we have the grant deed, and you meet with the seller, meets with the notary, they sign it. Here is a little bit different. In the case of a court confirmed sale, what the title company really needs is going to be the order. That's all. They're going to have a checklist. It's not just that, but one of the things that you need in order to ensure title and record is going to be that court order signed by the judge that authorizes the transfer of title.
And so do you wait for that to come in to list
Yes.
the property always?
No. So that is at the very end. So what you need in order to list the property, when you're in probate, you need something that is called the letters. They're letters of administration or testamentary letters, whatever. Every county has their little wording a little bit different. Like or people call it, address it differently. They're called the letters of administration. That's the easiest way to call them. So this is when the probate gets filed. There is an inventory. What does the person own? It's not just about the house. They own a house, they own a boat, they have this. You have to give a notice to creditors, right? Did they have credit card debt, et cetera, et cetera. People have rights, different rights, et cetera, on collecting. And once the letters are issued, then the person who receives the authority, whether limited or were limited or full, they have the authority to sign the listing agreement. So what I realize that happens a lot is that agents and by the way, there are wonderful realtors out there who are very good at this, but there's also people who are terrible at this. And I've noticed many times when they take a listing and maybe they have the wrong person sign, there's like an issue with that. And so be very careful what you do when you're selling probate. I used to get, it's funny because not so much anymore, but I used to get a lot of calls from agents who ask for advice because I come up on Google. If you look like for probate realtor, it's like in LA, I'm like the first one. And I would get so many calls from agents who wanted help and be like, hey, like, how do I do this? How do I do that? And I'm always willing to help. But then at some point I was like, look, it's your listing. You're calling me for assistance. Talk to the attorney. You're better off. Another thing that happened, Natalie, which actually really segues into the thing, and the reason why I decided to do the Probate Realtor Show was because a lot of people found me online and they would call me thinking that I was an attorney. They would call me and they would ask questions. Oh, my wife just passed away, or this and that, or this other thing happened, and da. And I would try to give the best advice as I could, saying, hey, I'm not an attorney, just so you know. So then I figured, instead of passing on the questions and trying to get like somebody to help, why don't I have a show where I put up the information, the episodes are there, and hopefully we index them well enough so that when people Google the question or ask ChatGPT now, what do I do in this case? They know, what to do. A lot of probates, believe it or not, are contentious because You know how siblings are, right? They don't always get
Right.
along. And
Yeah.
when they're contentious, there's litigation, and you don't need an estate planning attorney in those cases. You need a probate litigator. A lot of estate planning attorney like to stay out of court. They do probate administration and trust administration, which is the process of getting the probate filed and all of those things, or activating the trust. But they don't want to go to court. They don't want to fight, so they usually refer it out. So even asking for the right attorney, you got to know the question, and so that you got to know who you need help from. And some people don't even know. So hopefully by putting out the information, that makes it a little bit easier.
Right. And so what would you say are common like challenges for someone going into probate? What should they be most aware of or look out for? And what are the standard timelines to
So
kind
I
of
would
take into
say if you have a
consideration?
probate, not from the real estate standpoint, but from the standpoint of even a good probate that is handled fast, before you see the money is probably going to take a year, 6 months to
Okay.
a year. So it's somewhat of a lengthy process.
Okay.
When you are the administrator of a probate, one of the challenges is how much you will get bombarded by advertising, solicitation. Like I said, it's a public. Do you know,
Right.
Natalie, you know what happens when you have a client that comes to you for a mortgage and you run their credit, when the time comes to run their credit,
The
you know,
worst.
okay, you know what happens, right? It's because there is an inquiry of a mortgage. It's different than somebody doing a credit check,
Regrettably. So
right?
I'll tell the audience since they might not know. So
Yeah,
when I pull a credit report, a hard inquiry, which means we pull all three bureaus, which is
right,
TransUnion, Equifax, and Experian. When we pull a credit report from all three and we get a hard inquiry, the bureaus, for some reason, legally are allowed to sell your information
right,
other mortgage companies. And so we'll pull your credit, and then you will immediately get bombarded by 100 different mortgage lenders and brokers. And a lot of my clients come back to me and they're like, "You sold my information when you
right,
pulled my credit." And I'm like, "Okay, let's take a second. Why would I do that?"
right.
Like the very last thing in the world that I want are other mortgage brokers reaching out to you.
Right,
Trust me, if I could pay a service, and I would pay a hefty fee, if I could pay a service for my borrowers to not be bothered once I pull the credit, I would absolutely do that. Sometimes people are like, "I've had 60 people in the last hour text."
right. So
It's
this,
awful.
it's so imagine the same thing happens when you file a probate. It's the same thing. You're filing a probate, it's a matter of public record. Then you start getting letters, calls,
I
whatever, et
see.
cetera, et
And
cetera.
who is it? It's the courts or the county that sells the info that
So
there's a
no,
buyout?
they don't sell the info. It's because legal proceedings are a matter of public records. And if people know how to
People
find it,
pull public records, so they'll
yeah.
pull like
So
recent
what
probates.
happens is this, there are services, because you and I don't necessarily know how to, you don't know how to look court transcript up or get documents for probate. We don't do that every day, right? But there are people who are specifically doing those services. So they pull the records, put them in a system, and then they say like they charge $20 a month or $30 a month for
Yeah,
people to pull all the records. And that's how people get them. And they also have mailing lists where they send out the records. They have
sure.
all sorts of ways of looking up those things.
Got it. Yes.
No, so that's one of the challenges. It's in fact one of the episodes on my show was make a plan, avoid spam. It was the thing, like, because if your property is in a trust, you don't need to go through probate, or it's sold by or it's owned by a corporation, because a corporation doesn't die, but or an entity for that matter. But
Yeah,
the issue is that once you put it in a trust, you have to keep it in the trust, right? So if you put it in a trust, then the trust already has the directive of, say, hey, my eldest child is my successor trustee, so they're in charge of selling. When you do an estate plan, you have, I give 50 between the child, or if you have a spouse, or doing an estate plan is very important, especially if you have a second marriage or family from a previous
certainly.
marriage. Like, all those things are very important, because if it becomes if you don't have a plan, then who decides is the courts, and they have statutory regulations where they say this much goes to the children, this much goes to the wife. So think about it. If you're married, if you pass away, you probably want your spouse and the mother of your children or the father of your children to remain in the house and be able to until they no longer need it. But if you don't have any plans, I don't know exactly what the distribution is, but I think it's 1/3. I think it's 50% to the wife, and then something like that. So that division of inheritance gets decided by the court rather
Right.
than by you.
Got it. Interesting. And if it is in a trust, does the step up still apply?
Absolutely.
It
Yes.
does.
Whether
Okay.
even a corporation gets a step up in basis in the sense that let me fix that actually a little bit so that it's a little bit more complicated. A corporation gets a step up in the stocks when a person passes away, the stocks that own the property. So it's a little bit more complex. If you have a disregard entity like an LLC, which is the way that a lot of people own investment property, you still get the regular step up in basis but if you own it in a corporation like a C corp, then when the person passes, there is a step up in the stock. It's complicated. So this happens to very few people. Not very many people hold real estate in C corporations that are like, unless they're used for businesses, which is a different thing. If the person owned like a warehouse or stuff like that, then they may own it in a corporation for business purposes.
Got it. Got it. Okay. And do you know like the percentage of how many people do sell right away once something is in,
So what
like
I
the home
tell,
immediately go into probate when someone dies, regardless?
yeah, so it's not the home that goes in probate, it's the estate. So the estate is anything that is owned by the deceased. So stocks would go into probate. A retirement account goes into probate. Real estate, a car, whatever. It doesn't
Oh,
matter. The
wow.
person is dead. The estate encompasses everything,
They own.
everything. Their fur coat, I don't know, a jacket, their shoes, everything that is owned technically is part of the estate. Therefore, collectibles. We have in the high-end market, you have a lot of people that may own art collectibles that may be
Sure.
worth more than a home.
Jewelry.
Exactly, jewelry, diamonds, you name it. All of that is part of the estate. All of that, the administrator will have a fiduciary duty to making sure that they do the interest of the estate. The successor trustees, the same thing. They have a fiduciary duty, which means that they have to act in the interest of the estate, not their own. So if they have, let's say, 4 siblings, I have 4 kids in my case, so there would be 4 beneficiaries if they all behave. No,
Okay.
but let's just say that. So whoever is the administrator or the successor trustee should not act just in their interest, but in the interest of all the children, all the beneficiary of the estate. So
Got it.
so everything goes. So in order to answer your question, everything goes into probate, everything that the person owns. And
Interesting.
the percentage of how many people sell their homes when they go into probate is relatively high. Sometimes there's no real estate, so you can see a lot of probate filing, but it doesn't matter if there's no real estate. But if there is real estate that goes into probate, then I would say they're more likely to sell than not, especially because some people they moved out of town. Like I just sold the probate where they are in Chicago. They're not going to keep the house in LA if they're in Chicago. You know what I mean?
Yeah.
And that scenario has happened to me over and over again. I've actually worked with a lot of out of state, out of town sellers because that's the way family is. That's the way America is. It's mobile. People move to different areas of the country and then maybe they grew up in LA and then the family home is here and they have to sell it. So that's the scenario.
And so then how can investors spot opportunities in probate or trust sales? We talked about like you can go into county records and stuff, and anyone who files probate, you can see it. But like, are there always auctions on it?
No, only when there's limited authority, there's an auction. So if there's no limited authority and there's full authority, then the overbid process, doesn't take place. As an investor, here's the advantage as an investor is that a lot of these properties may be old and distressed, and some people may not want to repair or do any fixes. So as an investor, you have the advantage because you're going to fix the property. You have the advantage of making an as is offer. a lot of end users, people who imagine a first-time home buyer is not going to want to buy a home that has $200,000 worth of foundation work that needs to be done.
Not
They're
recommended.
gonna,
Yeah.
especially since they're buying with a loan, they're putting 20% down or whatever. They're not gonna have a nest egg that. On the other hand, if you're an investor, you just factor it in. You say, hey, I'm gonna fix the house anyway. I'm gonna take it to the studs. That's gonna be easy to do the work. So that's where you essentially spot the opportunities is in properties that are distressed. They had a lot of deferred maintenance. And as an investor, you can go in and you have the advantage of making as is offers. To tell the truth, it makes perfect sense for some people that don't want to deal with real estate, that this is a warning that I give to all of my sellers. If you want to do repairs or whatever, you have that choice, but do not become a real estate developer or a flipper yourself if you don't have any experience in the business, because you're going to end up it's going to end up costing you more. Nobody
Yeah.
wants to put $300,000 in a home so then they can resell it for $305,000 more. You got to make sure that you're getting your money's worth. And if you're paying retail, because you may not have your contractor or whatever, if you're paying retail for construction, it's difficult to make deals pencil in. Now, that's not always the case, but as a general rule, I always warn my sellers, before you get in the flipping business on your own, let's ponder. Let's look at the numbers, exactly what comes out.
Of course. Yeah. And when you do go to auction, if something comes that way, is it always full cash?
No, they can be purchased with a loan, no problem. As long as by the time you have to be non-contingent for the overbid to take place. So a lot of probates are purchased with a loan. That's another misconception that people are scared about. And
Totally.
Natalie, if you ever have a client that's thinking about buying a probate, feel free to reach out to me, because you could buy probates with a loan all day long as you factor in the risk. So meaning that somebody reaches out to you and says, look, Natalie, I'm thinking about buying this home. I cannot have an appraisal contingency. I cannot have a loan contingency. The price, what do you think? Any loan officer can say, oh yeah, it's gonna appraise, it's gonna be fine, or yeah, I understand. Just make sure that one thing you have to make sure is that you meet the requirements, because in California, you have to have things like the water heater. If it's a tanked water heater, it needs to be strapped. You need
Sure.
CO2 detectors. Some of these
That's all
homes,
easy. Yeah,
right, but they have to be livable. If an appraiser goes to the house and there's no roof, they're not going to give you a loan.
of course. It has
Yeah,
to be habitable. But
exactly.
where is so when I've done it in the past with clients, the risk level is very high because they have to give 10%,
Yes, and minimum 10% deposit, which is non-refundable.
which is non-refundable. And
Correct.
that's where it gets tricky. If I don't
Well,
have a total A plus buyer, because obviously we're not going to do an appraisal beforehand either. So if
mhm.
we don't have a total A plus buyer who has an extra few $100,000 in the bank just in case there's a problem with the appraisal, and also whose file is perfect and there's not any intricacy on it that could be messed up, then we do it. But it's very scary because 10% is a lot of money, of course, and for it to just not be refundable is like, how do you allow somebody to go in and do that when, for me, I'm responsible to get them this loan?
Of course, some people sell probates with contingency. So if it's a full authority
Oh,
probate, you
okay.
could do a probate with a contingency, with an appraisal contingency, because you don't have the pressure of having to do the court confirmation. So you can negotiate the contingencies. But when you do go to court, the problem is this. I guess the issue is this. Let's say you do have your contingencies. You go into escrow, you put the 10%, which is refundable. You do your appraisal, you do your loan contingency, you do your inspection, then you remove all contingencies. You're clear to close, you have clear to close, and you remove all contingencies and go to court to confirm. Now,
Hmm.
somebody shows up in court and overbids you. You get your money back, no problem. You get your 10% back, but you spent money on the appraisal, you spent money on the inspection. So that's something to keep in mind.
That's normal. Yeah. That's normal for
So,
anyone getting into escrow. It's those are
right,
the days
never
when you
know.
want to buy a
Exactly. You
home.
never know. Is he going to close?
Yeah,
What are you going to find when you do the
exactly.
inspections? Yeah.
Exactly. Exactly. All right, wonderful. That's our time. Thank you. That was overwhelming amounts of information.
I'm so
But
happy that it's been a pleasure to talk to you. And yeah, I love my job. So talking
you
shop,
can
it's
see,
just
you can
fun.
tell. Yeah, yeah, it's lovely. You can really tell. You can. Everybody, you can find Matias everywhere. YouTube, he has a website, Instagram, LinkedIn, Facebook, Twitter, TikTok, Pinterest, Zillow, Yelp, and
At,
I mean,
that's
like,
right.
amazing.
At
Uh,
Matias Broker. Most of this, it's at Matias Broker, even on YouTube. So you can find me at Matias, Matias Broker.
broker.
Follow me because I
And
put out a lot of content.
I love that. And we'll also have all that information in the notes and everything. So
Wonderful.
thank you so much for joining us and sharing so much of your great wealth and information. And thank you. If anyone has
Absolutely.
questions, please let us know. Yeah,
Yeah. Feel free to reach out. I'm an open book.
amazing. Thank you so much, Matthias. Thanks for listening to Mortgage on My Mind. If you're ready to start your mortgage journey or have any questions, I'd love to help. With 20 years of experience, I make the process as simple and stress-free as possible. Check the show notes for my contact info, and don't forget to subscribe, leave a review, and share this podcast. Until next time, I'm Natalie Salins, here to help make your real estate dreams a reality.